Hey guys, today we're going to talk about the schedule of assets and the supplementary affidavit, which are both filed as part of the probate proceedings. If you're navigating the probate process, understanding these documents is crucial. The schedule of assets is a detailed list of all the dead person's assets, the deceased person's assets at the time of their death. These would include bank accounts, brokerage and investment accounts, real estate, including HDB flats and condominiums, motor vehicles such as cars, lorries, vans, motorcycles, and other assets that are held with an institution or require a grant of probate or a letter of administration before a transfer or a sale can be effected. So the schedule of assets and the supplementary affidavit apply for both grant of letters of administration as well as the grant of probate. So regardless of whether you die with a will or without a will, you will still have to file this document. The schedule of assets is important as it determines the estate's value and ensures that all beneficiaries receive their fair share according to the testator's will or the Interstate Succession Act. Accurate reporting prevents disputes and potential legal issues down the line. The schedule of assets also gives the executor reassurance and protection against the risk that unknown assets and unknown liabilities may come up at a later date after he gets the grant of letters of administration or the grant of probate. Because if that happens after the grant is obtained, and the executor finds out that the deceased has other assets which were not included in the list of assets, then the executor has to get a lawyer, or he can do it himself, to take out an application to amend the schedule of assets, to insert that asset into the schedule of that specific asset into the schedule of assets. And taking out the application to amend, it's called a summons for amendment, is costly and it's messy because you have to, underline the amendment. And it's called amendment number 1, amendment number 2, and you have to do it underlined in black, in red, in green. Also, most institutions, such as the banks, the insurers, the Central Depository, the Land Transport Authority, HDB, Singapore Land Authority, will not release the monies or allow a transfer unless the specific bank account, or the policy number and the amount of monies in the bank account, or the insurance payout, the death payout, or the property address and the estimated value of the property, they will not release the monies or allow a transfer until that specific property is included in the schedule of assets. So here is what the schedule of assets looks like. When applying for a grant of probate or for letters of administration, the executor or the administrator must submit the schedule of assets to the court. This document helps the court understand the value and extent of the estate to ensure that everything is accounted for. If all the assets of the deceased are known at the time of filing the grant of probate, filing of the application for a grant of probate, or at the time of filing the application for a grant of letters of administration. For example, if at the time of filing of the application for probate or letters of administration, the executor knows that the deceased has an HDB flat at Tampines Block 234, unit whatever. The executor knows that the deceased has only one bank account, which is a DBS bank account, 1, 2, 3, 4, 5, 6, 7, and it has $55,000 inside. And he knows that the deceased has a Mercedes-Benz car plate 1234Z. Then during the filing of the application for probate, i.e. the originating summons, the schedule of assets can be filed together with the originating summons or within 14 days after issuing of the originating summons by the court, together with the supporting affidavit. So this is what the supporting affidavit containing an averment on the schedule of assets looks like. Sometimes the executor does not know all the deceased assets. I have clients coming to me with the copy of the will, or if the deceased died without a will, the family of the deceased, they'll say, I don't know, I don't live with him, I don't know what assets he has. I only know he has a HDB flat. I don't know what bank account he has. I don't know whether he has shares. I don't know whether he has insurance policies. So, in cases where the executor or the administrator is not able to confirm the details of the deceased assets early during the application process, the probate lawyer will have to do what is called probate due diligence to ascertain the assets and liabilities of the deceased. So this essentially involves writing to the local banks, the banks, the insurers, and even the brokerage houses, Maybank Kim Eng, Philip Securities, CDP. So my advice to executors or to administrators is to go through the deceased documents at home or open their mailbox to see any letters, whether they receive letters from Philip Securities or they receive letters from DBS Bank, OCBC Bank, Citibank, Standard Chartered. Open their mailbox to find out, to get an idea of whether they have any other bank accounts, or go through their documents that are in their house to see if they may have bank statements from a certain bank or insurance policy documents, If not, and you go to the probate lawyer and say, I don't know what assets he has. I don't see anything in his house. Then there's a possibility that the probate lawyer may have to write to all the banks in Singapore, all the insurance companies in Singapore, just to find out whether the deceased has a policy or has a bank account with the banks. And I have written up with like 15 banks before, and it's very costly and expensive, and the banks take a long time to respond. And you actually have to write a letter, it's not by email, it's a hard copy letter. You have to exhibit the originating summons, you have to exhibit a certified true copy of the death certificate, as well as a consent letter. It's a costly and lengthy process. Given that the supporting affidavit mentioned will still have to be filed within 14 days after the issuance of the originating summons, the probate lawyer will require you to sign the supporting affidavit that does not exhibit the schedule of assets yet, because in scenario 2, where you're not able to confirm the assets and you need to write to the banks and insurers, you just simply cannot, exhibit the schedule assets in a supporting affidavit within 14 days. So the supporting affidavit will only exhibit the statement, the death certificate, and the will if it's an application for a grant of probate. Thereafter, the court would grant an order in terms of the probate or letters of admin application based on the supporting affidavit, therefore without the schedule of assets. So in the second scenario, i.e. when the probate lawyer has to write to all the banks and insurance companies, in the second scenario, from this point on, after the order in terms, the probate lawyer will be able to write to all the relevant financial institutions and insurers to ask them for detailed information regarding the deceased outstanding accounts, monies, shares, securities, whatever. The financial institutions may take some time to respond. Once the probate lawyer receives the relevant information, the name of the institution, the bank or insurer, the account number or policy number, the amount of money in the bank, amount of the shares in the death payout of the policy, Once the probate lawyer receives such information and is able to complete the schedule of assets, you'll be asked to sign a supplementary affidavit before a commissioner for oaths. The supplementary affidavit will exhibit the complete schedule of assets. The probate lawyer will file the schedule of assets as well as a supplementary affidavit onto the e-litigation portal. So as I mentioned before, any future amendments to the schedule of assets will have to be done by way of a separate application. That's why you should get everything done in one go. So once the court accepts the supplementary affidavit and schedule of assets and confirms that there are no other documents that need to be filed, you'll most likely be able to get the grant of probate or the grant of letters of administration.